Thank you. I'm the Director of External Affairs for PMC, and welcome. We're so happy that you could all join us. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that, among other things, educates the public about courts, their functions, the laws which courts interpret and apply, and advocates for fairness, accessibility, and respect to the courts. We were founded over 35 years ago. PMC originally focused on supporting the elimination of judicial elections in favor of a merit selection process for appellate court judges. While PMC still favors a merit selection system, it has since expanded to educating students, journalists, lawyers, and the public at large, just like we're doing this evening. Thank you for joining us. Just a couple of housekeeping rules. You can put any questions that you have in the chat, or you can raise your hand, and we will do our best to answer them. Just as a reminder, we can't answer any legal questions, but we can give you suggestions and resources as to where to connect with legal advice. I'd like to now thank our co-hosts, which is our true partners. We've been partnering with them for a couple of years now, the Carnegie Library of Pittsburgh and the Allegheny Law Library. Lori, do you want to say a couple of words? Do you want to say hello?
Hi, Lori Hagan here. I'm a reference librarian here at the Allegheny County Law Library. We're located on the 9th floor of the City County building. We are open to the public. We are open from 9 to 4:30 Monday through Friday. Although this Friday, since it's Good Friday, we will be closed. But you're welcome to come and use our resources. We'll help you as best we can. Again, we cannot give legal advice either, since we are librarians here. Back to you, Michelle. Thank you.
Thanks, Lori. Now I'd like to introduce our presenter this evening. He, first of all, is a very, very good friend of PMC. He is a board member, David Sonenshein. He is, or a retired, although not fully, professor from Temple University Beasley School of Law. He was a professor for 35 years and taught, he was focused on civil and criminal litigation. Before that, he was a lawyer in Boston. He has written and co-authored many books, many law reviews, and we're very, very excited that he's here with us this evening. David?
Thank you, Michelle. And delighted to be sharing some time with my friends in Pittsburgh and Allegheny County. I've been to the library, Lori. It looks beautiful. Next time I'm in Pittsburgh, I'm coming to visit you.
Please do.
What we're talking about tonight is the criminal justice system, the way that it works in court. Before we begin with talking very briefly about the court system in Pennsylvania, which is fairly typical of most states in the United States, just a couple of items I'd like to mention when I'm speaking, particularly to non-lawyers predominantly, to sort of correct some public misperceptions that I think television and the movies have created. First of all, what is distinctive about the American system in criminal justice or in criminal courts is the fact of a jury trial. We are one of very few countries on the face of the earth that have juries. And we're the only country in the world that has civil juries. Even England no longer has civil juries. A number of countries, England among them, have criminal juries, but most do not. Most systems operate with 3 judges making the decision in criminal cases, guilt or innocence, and then setting sentence. So it is unique to the United States. However, if you watch Law and Order and you watch the various movies we've all seen, you would think that most cases in the American system go to trial. There was a time when that was true. It is no longer true. The vast majority of criminal cases in the United States never see a judge or a jury for a trial.
Wow.
Upwards of 98%.
Wow.
98% of cases in the United States are settled by a guilty plea arrangement between the defense and the prosecution. It sounds remarkable, and you wouldn't know it watching TV, but there are many, many American lawyers who, after 25 years of practice, have never seen a jury, or in fact, never had a trial in a courtroom, particularly younger lawyers, because there's so few trials now. When I was in practice in Boston many years ago, I checked and about 30% of cases went to trial. That is no longer the case. Now it's 1%. So things have changed dramatically. Number one. Number two, an uncomfortable number of criminal defendants in the United States, and I assume in other places as well, who are convicted are in fact innocent. It sounds crazy. If you don't look into it, it was sort of hard to imagine. And at least 25% of those people who are innocent and found guilty actually confessed to crimes they did not commit, which has been proven by DNA over the years. So at the moment in the United States, approximately 3,500 people who are innocent, many of them on death row, have been exonerated and are now free in the world. And if you look at the cases as I have, I'm a member of the board of the Pennsylvania Innocence Project, you would look at the case and say, how could it possibly be that this person was found guilty? I mean, the facts are not particularly close. And there are lots of reasons for that. We could talk about that a little bit, though that's not really the point of our discussion today. But just understand, thousands of people confess to crimes they did not commit. And police and prosecutors will agree with that. They will tell you that. Okay. The third thing I'll talk about is in so many TV shows, I watch a lot of the British detective shows, police detective shows, and there's a lot of criminal science and forensic science stuff. And just appreciate that most of which you see on TV has been already thrown out of court as bogus. The bite marks have been abandoned by the FBI 25 years ago. There's no such thing as the science of bite marks. Hair comparison does not exist. Arson evidence on the cause and origin of fires. We've had hundreds and hundreds of people exonerated because arson evidence was not scientific. I will tell you this, and you hate to hear it, I hate to say it, fingerprints themselves, which used to be the gold standard, now are considered by scientists to be not particularly reliable. And the reason is that the science is not really a science. Some fingerprint people look at 4 matches of parts of the fingers. Some look at 16. And some say, if I don't have 16, that's not a match. Others say 4 is good enough. And people get convicted and go to the electric chair. This has happened more than once. And finally, I will say this in favor of science, because real science is good science. DNA is the gold standard. And when DNA is there, that's legitimate. And no one in a court at any point in this time in our history challenges DNA evidence. They may challenge the way it was collected, in that whoever was the crime scene people may have contaminated it or something else. But the science of DNA is 100% accepted by everyone. So when you see somebody is either convicted with DNA or exonerated with DNA, you can be pretty sure that that's an accurate result. Okay, so I hope we can move on now to what the little slide in front of you shows, which is the Pennsylvania judicial system, which, by the way, is the same for civil and criminal cases. Trials are held on significant cases, that is not the small ones, in the Court of Common Pleas, which you see at the bottom, toward the bottom of the slide. And there's one in every county. Obviously, Allegheny County has a Court of Common Pleas, Philadelphia County, Lucerne County, everybody does. This is where the vast majority of significant trials take place in Pennsylvania. And in fact, it's the only place where you'll see a jury trial. Okay, so that's point one. Point two, if you're going to appeal a criminal case, you will appeal to the Superior Court, which is an intermediate appellate court. That is to say, everyone has an absolute right to appeal. I should say the government cannot appeal a criminal case and not guilty because of the Fifth Amendment. But the fact is, if a defendant does not like the results of his or her trial, gets convicted, they have an absolute right to appeal to Superior Court. If you lose in the Superior Court, then you have the chance, but it's a tiny chance, to get the Pennsylvania Supreme Court to hear your case, because they only hear the cases, it's going to sound funny, they feel like hearing. And if they say, this is a case, I'm interested in this case, we'll take this one. It's a tiny percentage, tiny percentage. In the US Supreme Court, which is the equivalent, of course, right? In the federal system, there are 5,000 appeals taken to the US Supreme Court every year. They hear 80. And you might say, wow, how did I miss having that job? They hear 80 cases a year. There are 9 of them, and they each have 4 law clerks. You got to wonder about their workday. But in any event, I won't say the same thing in Pennsylvania. They take more cases. So your case ordinarily really ends in the Pennsylvania Superior Court for all intents and purposes, okay? Now, one point about appeals. And you'll hear this soon in the next couple of weeks and months, plenty of times, I'm sure. Every time somebody gets convicted, they come out of the courthouse with their lawyer next to them, and the lawyer invariably says, we're filing an appeal. This case will be overturned. We will be exonerated. This was a terrible miscarriage of justice, etc. I'm going to be hyperbolizing a little bit here, okay? You have as good a chance of winning a criminal appeal as being hit by lightning, okay? It is extraordinary for a criminal case to be reversed on appeal in state or federal court. It's remarkable for that to happen. Now, I'm not saying it doesn't happen. Of course it does. But the fact is, don't take it face value when lawyers come out of the courthouse and say, oh, we're going to appeal. That means nothing. In 95% of cases, that is a waste of money, because most of the time, appeals are, particularly in criminal cases, are not taken in reverse. That does not happen. Very often, I should say. Okay, so we can move on a little bit. And I think there's another slide. We're talking about the process now and a little further up. And the way it works very simply is this. I shouldn't say simply, it's actually too complicated to tell you the truth. And that is, somebody is arrested. In the United States, of course, in state courts like Pennsylvania, the police investigate crime, make the arrests, and then do the charging of the defendant. Then they get involved, by and large, with the prosecutor, who gets involved for the pretrial and trial proceedings. In federal court, and in most states, there is something called an indictment, which you all heard about today, I'm sure, at 2:15. And that's because 48 states, excluding Pennsylvania and Connecticut, require a grand jury, 23 citizens, to actually charge a suspect to make that person a defendant. And a majority of the 23 must vote to indict. Pennsylvania and Connecticut, for historical reasons I don't really know the answer to, do not use indicting grand juries. It's all decided by the prosecutor. And one thing you must appreciate is the extraordinary power of prosecutors. Prosecutors have, and again, this may sound odd to you, absolute and complete discretion as to whether they want to charge somebody with a crime. Let me give you an extreme example. The district attorney of, let's say, Philadelphia County, let's say Allegheny County. I'm not saying they've ever done this, obviously, but if they're walking down Broad Street in Philadelphia and see somebody pull out a gun and shoot another guy in the head, that prosecutor is free to walk away and say, I'm not charging anybody. And there's nothing you can do. Nothing anyone can do. except when he runs for re-election or she runs for re-election, vote him or her out. Prosecutors in the United States, I don't think this is a very bad thing. There are good reasons for it because you don't want every single decision to be reviewed. But they have absolute discretion. The Supreme Court said that in a big case from Louisiana 10 or 15 years ago, just in case there was any doubt, there really wasn't. Okay. In Europe, a prosecutor is required to charge a defendant if a crime is reported to the prosecutor. There is no discretion, none whatsoever. In the US, a prosecutor can say, if he or she wants, I don't believe in this law. I'm not going to charge anybody in this. Or I don't like people who look like this, so I'm not going to charge anybody. And there's nothing you can do except knock that person out at the next election. Now, that brings up another issue, which is very big in the minds of Pennsylvania for modern courts. Prosecutors, like judges in Pennsylvania, are elected, and they run as Democrats and Republicans, and they can accept campaign contributions legally from lawyers, from law firms, from big corporations, from labor unions, including those appearing before them in court. And that is not a crime in Pennsylvania. Okay? Now, many states have elected judges. Massachusetts, where I practiced, elects its judges and is done to what's called merit selection. That is, the governor appoints the judges at all levels of the courts, but the governor has to pick from three people who come through a screening commission of a blue ribbon group of law school deans and very, significant people who give the governor three names. Said, you can pick any of these three. If they're not your friends, too bad, right? And the governor is required to pick one of those names for every judgeship in Massachusetts, okay? And in many other states. Illinois elects judges, Pennsylvania elects judges, and I think many of us think that electing judges is not an appropriate thing to do. Judges shouldn't run for election, in my view. They shouldn't be running on platforms of, here's what I'll do with the law. The law is the law, and it shouldn't be Republicans and Democrats. Either way, I don't care. That's just wrong. But that's the way it is in Pennsylvania, and I don't think it's particularly going to change anytime, particularly soon, I'm sorry to say. But Pennsylvania isn't alone. Illinois, Texas, a whole bunch of other states do the same thing. And I think it's a system that is not necessarily the kind of system we all want. This isn't to say, and I want to be fair, there are plenty of good elected judges. Of course there are. Of course there are. And I know many of them who are friends of mine. And they're not good judges because they're friends of mine. They just happen to know them. But the fact is, I think most people agree, most lawyers would agree, electing judges is not a good idea. Again, we're the only country in the world where that happens. Nobody else even thinks about doing it this way. All right, so the police make a decision to arrest you in Pennsylvania. You go before a judge within a couple of days. Judge decides, is there enough to hold you? If so, the judge then decides on bail. Often people receive bail. The question is the bail excessive? In other words, if you give somebody who hasn't got a job a $200,000 bail, well, you haven't really given them bail. You've decided to keep that person in jail, a pending trial. And in fact, if you give $200,000 to a billionaire, you're saying to that person, you're free to go. So there are real problems often with setting bail. More people get bail than not. People charged with murder cannot get bail. And I think we all understand why that is. But in any event, if you're out on bail, you can go to work, be with your family, go to your job, etc., and help your lawyer prepare. If you're not, if you don't get bail, you're in jail until the time of trial, which may take a year, in which case you've lost your job, you probably have lost much of your family. And of course, remember, you're in jail on bail, but because of a bail setting, you may well be innocent, and yet you've lost everything. So the bail issue is a very lively issue for discussion. There are lots of reform proposals around about that. Once we're done with that issue and the case goes to trial, there are three main actors in the trial. First, I mentioned the prosecutor. who of course is the person who has to then, having already decided to bring the charge, put on the case against the defendant. And of course, you've all seen this, if nowhere else on television, or you've attended a trial yourself and seen this. And I have to tell you, as a lawyer who was always involved in practicing and teaching the litigation part of being a lawyer, I think this is the best part about being a lawyer, is being able to go to court and be able to make arguments, try cases, and examine witnesses. And I think it's the most interesting. Many lawyers will disagree with that. I understand that. Okay, so the prosecutor puts the case on. The judge's role, again, only in the United States, not in Europe, is to, if you will, be an umpire, call balls and strikes. So the judge does not examine witnesses. The judge does not choose the jury. The judge only does really two things. During the course of the trial, if one lawyer tries to offer evidence that is inadmissible evidence, that the jury is legally not supposed to hear, the judge then hears that objection and makes a ruling and decides whether the jury can hear that evidence or not. Other than that, the judge doesn't really say very much or do very much till we get to the end of the trial, when he, of course, gives the jurors the instructions on the law, because jurors are by definition lay people, like most of us. Okay, very rare to find a lawyer on the jury. Every so often one slips through, but most of the time no lawyers want another lawyer on the jury. So somebody has to tell the jury, you're not experts in antitrust law or products liability. Here's what the law is, and then the jury goes out and does its job. The second major actor, of course, is the defense lawyer. The defense lawyer can come from one of three places. First, in the United States, everybody, of course, for a case that's at all serious, that is, could carry minimum at least 6 months in jail, which is, you know, most significant cases at least, you have an absolute right to have a lawyer. Now, that was not always the case. That was not the case in the United States till 1965. If you can believe it, prior to 1965, most criminal defendants in the United States went to court in criminal cases without a lawyer. They represented themselves. And if you think about that, it's almost extraordinary. It really is extraordinary. Only in capital cases did the law usually require a lawyer to be appointed. In any event, let's put those cases aside for a moment. In every major criminal case, or every criminal case that's, you know, more than a small case, you have a lawyer who could be one you hire and pay out of your own funds. And for many of us, frankly, that's very, very expensive. In fact, most lawyers I know would tell you, I could not afford to hire me. I couldn't afford to hire myself, right? Because the hourly fee that you pay, which they're getting when they're representing somebody, is more than most middle class and certainly working class people can afford. So that means most people are represented either by public defenders who are paid for by the county or by the state, or by appointed lawyers. That is, the judge in the case will pick out a lawyer and say, I want you to represent this person. The problem with appointed counsel in the United States is the pay that the counties and state give them is tiny. It's minuscule. It's 1/10 of what private lawyers get. And there's a cap on it, which means you'll run out of money in about 3 weeks in trying to represent somebody properly. So you've got a real problem with appointed counsel, often people doing the best they can and trying very hard, but up against tremendous problems with lack of money, heavy caseload, et cetera, et cetera. I was a public defender in Boston early in my career, so I have a certain affinity for the public defender's office. I would have to tell you, in my experience, and I'm sure there are plenty of lawyers who take appointments would disagree with me, but I think public defenders are your best shot in many, many of these situations. I will tell you that in the Innocence Project, where we get many people released from jail because they were innocent. And one of the reasons we get them out of jail is because they had what's called ineffective assistance of counsel. The Sixth Amendment to the Constitution says you not only have a right to a lawyer, but a lawyer who does a reasonable job, right? In all the cases we've done, exonerating people on ineffective assistance of counsel, not one has been against a public defender. Not one. Think about that for a minute, okay? Not a single one, okay? So I have great confidence in public defenders. Are they overworked? Yes. Are they underpaid? Not as badly as appointed lawyers who are paid very poorly, right? And they do have some resources. They have investigators, they have social workers, a variety of things. But whenever you see on television, suspects in police lockup saying, I want a paid lawyer, I want a lawyer, who, et cetera, et cetera. I don't want a public defender. Many of those people are making a big mistake. They're making a big mistake. So don't have that television bias against public defenders. They do a very, very fine job under very difficult circumstances. And many appointed lawyers do as well. But the fact is they're up against enormous odds in terms of lack of resources. So we've talked about the judge, the prosecutor, the defense lawyer. We also, of course, have the jury, who are ordinarily 12 citizens who are chosen because they don't know anything particularly about the case and because they have no favoritism one way or the other. Now, appreciate when you're called for jury duty, and I hope you all will show up and do it. I've tried, but I keep getting bounced out because nobody wants a lawyer, okay? They're going to ask you questions to see if you're biased. And if you choose to lie and say you are not when you are, there's nothing anybody can do about that. You will be on the jury. And those biases will come out during jury deliberations. And once the jury is deliberating, the fact that there's a biased juror is not a basis to get the case reversed on appeal. So it's very important that when you are going to be selected or up for selection for a jury, you must tell the truth when asked by the judge or the lawyers about if you have, relatives who are in the police department, relatives who are in prison, if you've ever been involved in the criminal justice system, whatever it might be, you really have to tell the truth, or the entire process, I must say, is destroyed. So in the end, I've mentioned the jury last. The jurors are the most important people because the jurors are free to make any decision they want. And in fact, you might be surprised to know this, the jurors are free, and judges most of the time will not tell you this because it's a bad thing, to disregard the law and do anything they want. There are a couple of states, I think Wisconsin, where the jurors are actually told that they can ignore the law. You can in the United States. I think it's a terrible thing. Jurors ordinarily don't do that. Most jurors are much more conscientious and honest and will try to follow the law. It's sometimes very complicated, but do their best to follow it and do the right thing. But there have been cases certainly where jurors have said, forget that. I don't agree with that law, not guilty. And you can do that, and there's nothing anyone can do. So I think it's important that all of you appreciate the importance of jury selection and trying to weed out folks who aren't going to be fair. And you have an obligation, and I think every lawyer, judge, whatever would tell you this, to be honest. So if you do have some reason why it can't be fair, to say that. And you'll be excused. There are people who say it even if they don't, so they want to get excused. I understand that, okay? But you really have to try to be honest in those situations. So in any event, that's how the trial system operates. However, many criminal cases are effectively decided before there is a trial. And that is in what's called pretrial proceedings. And now we get into the stuff, much of which you see on TV. which are motions to suppress evidence.
David, one question.
Please.
Someone is asking, can a paralegal can be a juror?
Yes, absolutely.
Great.
Absolutely.
Thank
And
you.
in fact, in Pennsylvania, a lawyer can be a juror, but he always gets stricken by the lawyers in the case because they don't want a lawyer in the room. The fear, of course, is that if there's a lawyer in the jury room, that person will, of course, control what goes on either way. And nobody wants that. We want the jurors to decide. That's the reason. But yes, anyone can be a juror in Pennsylvania. Some states forbid lawyers, but not paralegals anywhere. Okay, their motion to suppress evidence. You've seen all this on TV. Search and seizure, right? Police officer stops somebody, searches that person on the street, and if that search is done without probable cause, that is a reasonable belief that the person is doing something wrong, carrying contraband or a weapon, then that person moves to suppress the evidence that is taken because it's illegally obtained and brings a motion to suppress. The judge then has the power to say, I'm throwing that evidence out. Okay? And many Americans can understand that. But wait a minute, the person was apparently guilty. We're letting him go or her go because the police screwed up, right? And that's exactly what the Constitution says. Now, we don't like to do that. No judge loves doing that. But if we didn't do that, there would be absolutely no deterrence from the police to totally ignore the Constitution. In New York, for example, where there was a big stop and frisk case that went to federal court, New York has now totally changed its rules because of this case. Philadelphia has as well, by the way, changed its stop and frisk rules. New York police, you're not going to believe this, we're stopping 800,000 people a year. 800,000 people a year, okay? 800,000 people a year. We're walking down the street and we're being stopped and many of them searched or frisked at least by police.
For no reason at all?
Correct. Now, some of them were for a reason, okay? But 800,000 total, the vast majority for no reason, okay? Now, we can get into why they might do that, which is much broader than this meeting tonight. But the fact is, what's important and telling about this is the following. In New York, they had the statistics from NYPD. The number of weapons seized in New York stop and frisks was under 1% of the stops yielded a weapon, and half of that yielded drugs, okay? Which tells you that there likely was no good reason for a lot of those stops. I'm just gonna refresh this so I can get back on here, okay? In New York now, I believe last year they stopped 120,000 people because now they have to document why they're doing it and give the reasons as opposed to, it looked bad to me or I had a hunch, okay? And so if that happens, then the weapon is suppressed. I don't like that. I don't like weapons out in the world, believe me. But otherwise, the police could stop 8 million people in New York every year and stop everybody they like, okay? That's the alternative. And so that's why we have to have these rules. Very few, if it makes you feel better, if you're worried about it, many few suppression motions work or win. Often the prosecutor realizes this was a bad search. I'm dropping the case, for example. The two other major items for motion to suppress are interrogation, that is bad interrogations yielding yielding confessions, which are coerced by the police. And the third are eyewitness identifications. And I think probably everyone who knows anything about this subject, prosecutors, defense lawyers, law professors, judges, will tell you that eyewitness identifications are probably the worst evidence, the least trustworthy evidence there is. And in fact, most good prosecutors will tell you, I will not go to trial with only an ID, or I will not go to trial with only a confession. I want some physical evidence. I want something. I want fingerprints. I want DNA. I want something that indicates this person really was there and did it. So if the identification procedure run by the police was suggestive to the witness, I mean, you can imagine obviously extreme cases, right? I mean, there are 8 people in the lineup. Most of them, by the way, are off-duty police officers, okay, who show up for the lineup to help out their colleagues, right? But let's suppose they had 1 white guy and 8 black people. Well, I mean, that's ridiculous, okay? That identification is going to be suppressed. Okay, or if the police or prosecutor are suggesting to the eyewitness who it was, okay, then that eyewitness identification is thrown out of the case, and you have to proceed without that. The third, as I said, is confessions, which will be suppressed only if the judge finds that they are in fact coerced, either in violation of Miranda because the warnings weren't given, which is extraordinarily unusual. Police, I will tell you, always give the warnings. Okay, that's not an issue. Many officers carry them in their hats and their caps, just so I have it word for word, pull off their cap. Many of them, of course, don't even need that anymore. They know it so well. All of you know the warnings from watching TV very well. But there are still coercive matters that take place in interrogations, which have led to many, many, many false confessions and exonerations. Just appreciate this. In the 25 to 30% of those 3,500 exonerations in the United States, 25 to 30% were false confessions. Okay? Appreciate. If those people were convicted, despite having a false confession, the judge still allowed the confession in. That's why they were convicted. Okay? And the problem with this is something you might expect. The judge has to see a lot of people. The judge has to see police officers in front of him or her all the time. And the judge often, feels like police officers are doing a difficult job. And if the police officer said X and the suspect says Y, guess who's going to believe most of the time? Okay? It's going to be a police officer. Okay? And there are cases in New York where they had to revisit in Brooklyn, I think 200 convictions, because there was a police officer in Brooklyn, a detective, who perjured himself at least 200 times. And all those cases had to be turned over and done again. Now, I'm not saying again, I'm not criticizing all police. That's not the point, okay? But when it happens, it has to be dealt with. It has to be dealt with. We can't, in a free society, allow that, okay? And it doesn't say police are bad people. It doesn't say they do this most of the time. What I'm saying is when it happens, the law is there, and hopefully the judge is there to make sure that illegally obtained evidence is not used in violation of all of our constitutional rights. Now, sentencing. In America, the judge does the sentencing. In Europe, the jury does the sentencing. Or I shouldn't say the jury, it's the people who try the case, the 3 judges, and they sometimes have lay people with them as well, do the sentencing. In the United States, it's always the judge, except in capital cases where there's a death penalty, in which case the Supreme Court has said that there must be a jury involved in most of those cases. Okay? And there's a separate hearing, a death penalty hearing after the trial when somebody's found guilty of first-degree murder to see if that person will be given the death penalty or life in prison ordinarily without parole. Now, I want to talk about the defense lawyer's issue for a moment. The hardest decision every defense lawyer has to make is to whether to have his criminal defendant client testify. As you probably know, under the Fifth Amendment, right, in America, in most European countries too, the criminal defendant does not have to testify. Okay, he or she can choose to remain silent, and the judge will instruct the jury, ladies and gentlemen, the criminal defendant has the right not to testify. Okay, you may not assume anything bad from that he's hiding anything, or is afraid of you or anything else, that is a non-factor, okay? But bear in mind, bear in mind, there are very few psychologists, social scientists, and lawyers who will tell you that the jurors don't, despite their best efforts, and the instruction from the judge not to hold that against the defendant. It's human nature. And it's human nature for this reason. And think of yourself in the position of a juror. I remember there was a case I taught in criminal procedure for many years. It was a mass murder in California, the first serial killing case in the United States back in the 1970s. And this guy was charged with killing 25 people. It was absolutely awful. Never took the stand to deny it. Okay? Now, after they interviewed the jurors after that, and the crimes were heinous. I mean, it was awful. And they asked the jurors, what'd you think about his not taking the stand? And they all said, are you kidding me? If I were charged with being a mass murderer, I couldn't get up there fast enough to say I didn't do it. Okay? I couldn't imagine not denying it. Okay? That's human nature. Okay? Unfortunately, the law says you're not supposed to do that. But I think most of us understand often that does happen. Often that does happen. So the system, I think you're starting to appreciate, not perfect. Okay? Nobody pretends it's perfect. Now, the reason a criminal defendant might not testify, there are 2 or 3 big reasons. One is the criminal defendant has a prior record. And if the defendant has a prior record, the jury will not hear about that unless he testifies. And then the prosecutor can ask him about his record to attack his credibility or her credibility. Okay? Now, some of you might say, wow, shouldn't a jury know that if this guy's committed, 4 other crimes just like this? Well, the law says you're not supposed to know. Okay? I think many of us understand that. I'm thinking as a person on a jury, I would like to know that, quite frankly. But in any event, the law says you can't know. So if the defendant does not take the stand, the jury will not hear about his or her prior record, which is a tremendous advantage, as opposed to hearing the person's a career criminal, right? Which obviously will be very prejudicial. Maybe it ought to be. I don't know, but it'll certainly be prejudicial. Okay?
David, we have one question.
Sure.
Sorry. Silence. Does that means confession?
Yes, silence has a couple of meanings. When we say have the right to silence, it means in 2 places. One, you can remain silent during the interrogation. Okay, and no one can hold that against you. Number one, and good advice, by the way, from every good criminal lawyer will be when you're arrested, don't say a word. Any lawyer who tells you not to do that or that tells you to talk is making a tremendous mistake. That is just wrong. That to me is almost malpractice per se, okay? The second purpose of silence is at trial, when you have the right to remain silent during the trial and not take the stand and testify. Both of those are guaranteed by the Constitution, okay? Both of those. So the silence is both during interrogation, that's what the warnings are for, and then also at trial as well. The other reason why many times, and I understand this, defense lawyers will not want their client to testify, is very often, criminal defendants are not usually highly educated, particularly violent offenders. They're not, as sophisticated as white-collar criminals who've been to Harvard Business School or Wharton or someplace like that, right? And they don't present well. They may not speak well. Some may have problems that, get in the way of giving good testimony. And the fear is that person won't appear, even though innocent, won't appear well, and the prosecutor will destroy that person on cross-examination. Bear something else in mind I haven't mentioned, and I really should. The majority of people in prison in the United States, and again, something not to be proud of, we have more people in prison than any country in the history of the world, more than China, more than Russia, okay, more than South Africa, okay, more than 50% or up to that number are mentally ill or are mentally disabled. The Cook County Sheriff was on 60 Minutes, I don't know, 10 years ago. And Cook County, and he runs a Cook County jail, which where people are held awaiting trial. He said, there's no question in my mind that 90 to 95% of the people I'm holding right now in the Cook County Jail are insane or mentally disabled with IQs 70 or below. So remember that when you're a defense lawyer, do I want to put a mentally disabled person on the stand? But, you know, are you going to advertise that to the jury? No, I mean, you can't, right? So there are plenty of good reasons why you wouldn't. I think it's a very hard call. It's a very, very hard call. And so that to me, as a criminal defense lawyer, is probably the hardest decision you ever have to make. One other point I was going to make. Oh, yes. The nature of the appeal process is very limited in the United States. You may only appeal because the trial judge made a mistake. That is, gave the wrong instruction to the jury, which doesn't happen all that often, right? Because the judge is reading the instructions from a list provided by higher courts, okay? Or the judge has made a mistake in letting evidence in that shouldn't have come in. And that can be a tougher call for a judge, no question about that, okay? You cannot appeal essentially on any other grounds, which is why limited appeal is so significant. In Europe, it is completely different. In Europe, when you file an appeal, you essentially can start the case over. You can call new witnesses. You can bring in more evidence. And they go on forever. In Italy, you may remember the Amanda Knox case. Many people knew about. She was convicted. She appealed, and the first appeal was like a brand new trial. And it sort of went on and on and on. The other issue that's different in other countries I'll just mention to you is in Europe, in Italy, for example, where I've taught a lot, the Italian Supreme Court takes 15,000 cases a year. We take 80, okay? But there are 200 judges on the Italian Supreme Court, not 9. And they sit in panels of 3 because everyone in Italy has an absolute right to take an appeal to the Italian Supreme Court, okay? Their backlog in the Italian Supreme Court is 10 or 12 years before they'll get to your case. Well, that's a problem too. It's nice you all get to appeal, but look what happens, okay? Finally, there's something called post-conviction relief. That is, after you've been convicted, if you discover some new evidence or something has changed dramatically, you have the ability to file a motion essentially for a new trial, even years later. If you have just recently discovered new evidence or something that indicates you're likely innocent, again, those are very hard to win. In all of the Innocence Project cases where there have been exonerations, lawyers for the Innocence Project have won those cases, and they often take many, many, many years. And the person has probably already been in jail 10, 12, 15 years, even before the case has been taken. So just if I can sum up just a little bit, and you may have some questions. People say we have the best system in the world. Our system's good. I think in many ways our system is better than most others. In some other ways, probably not so good. In Italy, it's illegal to have a plea bargain. Everybody, the judge wants to hear a trial, hear the facts in every case. And I think that's probably a good thing. We can't do that here. We have too many criminal charges. We'd never be able to hold enough trials. I mean, so there are differences. There are people in Italy will tell you, or in France or Germany or Portugal or Spain, we think it's better to have judges decide the case. People who know the law, people who've seen hundreds of witnesses in their careers, have maybe a better sense of who's telling the truth, who isn't, right, than jurors. People in Europe cannot believe we allow regular people to make these decisions. When I talk to them about it, their mouths drop. They just can't believe that regular people do it. Okay. And that is probably good. Most judges I know will tell you that the vast majority of times the jury will find and render a verdict, probably the same verdict the judge would have.
Mhm.
That there isn't all that much difference. And studies have been done, and at least 75% of the time they would come out the same. And most judges I know, and that study was done 50 years ago, most judges I know will tell you the vast majority of times the jury gets it right, which is nice because it's in the Constitution and it's not being changed. So any of you think there's going to be an end to jury trials, forget that. That's never going to happen. That was a big thing for Thomas Jefferson. And so it's in the Constitution. And that, of course, is a very important part of our system. So that's kind of as much as I wanted to say. And if there are any questions, I'll be glad to take them.
I don't see any in the chat. Does anybody have any questions? Please put them in the chat or raise your hand or unmute yourself. I think we're good.
I
yes.
just want to say
Wait,
one
we have
thing.
one. We have
Oh,
one.
good. Okay.
Very informative. Thank you, Lori.
Lori.
Anybody else? Asked to unmute. Anybody else?
I just want to say to our friends in Pittsburgh, you have what I consider to be the nicest ballpark, baseball park in America. And I just wish, going back to days when I was younger and remembered the Pirates when they were the real Pirates, I wish them well and hope they get back to where they used to be.
Wonderful. Kathleen, can you just move forward just one more slide or another? Yeah. So I just want to share, please, if you're interested in getting involved in Allegheny County, we have a bail review. We train our volunteers. They go into the courts, they assess them, they fill out and help us create reports, and then we provide feedback. So that's really important. So if you're interested, please reach out to us. And then another slide, I think there's a QR code. Oh, these are the two. Okay, perfect. Oh, yes. Thank you, Kathleen. So these are our programming. So please get involved if you'd like. The next slide. Next slide is, we just want to remind you that it is a year for voting for the judicial elections. It's really important. We have 2 candidate forums that are coming up, one on May 9th and then another one in October. So please register just to be informed so that when you go in to vote, you are knowledgeable about the candidates. We really appreciate that. And then the next slide. Questions, we went through that. And then if you would really do us a favor, please just put up your phone and answer 1 or 2 or 5 questions. It's really important to PMC for our funding, for our grants. Well, thank you so much, David. We really appreciate your time and your knowledge. Thank you, everybody, for joining us, and we'll see you at the next one. This is recorded, and you'll see it on our website, and we'll also follow up with all of the folks that are registered with a PowerPoint, a copy of the PowerPoint.
Thanks, Michelle. This was fun as always.
Thank you. Bye, everybody.